of Justice threatening to sue Virginia if Governor Abigail Spanberger signs a bill aiming to restrict guns.
She's a leftist, and she doesn't like guns or gun rights. Former CIA operative.
People across our Commonwealth and the rest of the country have been impacted by acts of gun violence.
I did warn Governor Spanberger that if she signed that bill, that we will immediately file suit. As far as she hasn't signed it.
The law makes it a Class 1 misdemeanor to make, sell, buy, import, or transfer an assault firearm.
I can't believe what this new Governor Spanberger has done to the Commonwealth. People that voted for Spanberger are saying to themselves, why did I do that?
Spanberger said she signed it because, quote, firearms designed to inflict maximum casualties do not belong on our streets.
I know that Congress must reinstate a ban on the manufacturing, sale, and transfer of military-style weapons.
We're ready to take on every avenue possible to make sure that this law gets blocked and that Virginia citizens have the right to keep and bear arms.
The Department of Justice just sent a formal warning to the state of Virginia telling them that if they sign proposed gun restrictions into law, including bans on commonly owned semi-automatic firearms like the AR-55, the federal government is prepared to file lawsuits and seek injunctions to block enforcement before those laws ever take effect. That has never happened before. Not like this. The DOJ's Civil Rights Division, the same division that enforces voting rights and housing discrimination laws, just told a state government that your Second Amendment rights are civil rights, and they intend to protect them proactively. Not 5 years from now, after some gun owner goes bankrupt fighting a lawsuit, but now, before the damage is done. I'm going to break down exactly what this means for you, why this changes the entire fight, and what it signals for every restrictive state in the country. Here is why you need to care about this, even if you do not live in Virginia. If you're in New Jersey, New York, California, Illinois, Maryland, or any state that has been stacking unconstitutional gun laws on top of each other for decades, the strategy that just played out in Virginia is a direct threat to the framework your state has been hiding behind. That framework is simple, and it has worked beautifully for anti-gun legislatures for years. They pass a law they know is constitutionally questionable. They enforce it immediately. They make you the gun owner. Spend your own money, your own time, and your own sanity fighting it in court for 3, 5, sometimes 7 years. And during all of that time, the law stays on the books. Dealers cannot sell you what you have a right to buy. You cannot carry where you have a right to carry. You live under restrictions that everyone involved knows will eventually fall, but the state faces zero consequences for imposing them in the meantime. That asymmetry, that rigged game, is what the DOJ just signaled it is done tolerating.
The Department of Justice threatening to sue Virginia if Governor Abigail Spanberger signs a bill aiming to restrict guns.
Virginia Governor Abigail Spanberger signed a series of gun control bills toughening a proposed assault firearms ban.
In the Commonwealth, we know far too well the horrors of gun violence that impact our communities.
To make it illegal to sell, buy, import, make, or transfer assault weapons in Virginia starting July 1st.
She's a leftist, and she doesn't like guns or gun rights. Former CIA operative.
All right, so let me walk you through exactly what happened and the legal architecture underneath it. The Virginia legislature had been advancing a series of proposed gun restrictions. Among them were bans targeting commonly owned semi-automatic firearms, specifically AR-15 style rifles. Now, I need you to understand the constitutional framework here, because this is the foundation of everything. In District of Columbia v. Heller, decided in 2008, the Supreme Court held that the Second Amendment protects an individual right to keep and bear arms unconnected to service in a militia.
Spanberger is at the center of some controversy here following her decision to sign and then toughen a series of gun control bills.
She's all about big government, and so she'll sign that, and then we'll end up challenging it.
The amendments would ban the sale, transfer, manufacture, and importation of assault firearms defined as semi-automatic rifles.
People across our Commonwealth and the rest of the country have been impacted by acts of gun violence.
In McDonald v. City of Chicago, decided in 2010, the court incorporated that right against the states. That means state and local governments are bound by it the same way the federal government is. And then in New York State Rifle and Pistol Association v. Bruin, decided in 2022, the court established the test that governs every Second Amendment case going forward. That test says that if a firearm regulation burdens conduct protected by the Second Amendment, the government must justify it by demonstrating that the regulation is consistent with this nation's historical tradition of firearm regulation. Not a modern policy argument, not a public safety rationale. Historical tradition from the founding era. That is the standard.
The Civil Rights Division will seek to enjoin any attempt to infringe on the right of law-abiding Virginians.
Background checks are proven to help law enforcement keep guns out of the hands of those who pose a danger to themselves.
I did warn Governor Spanberger that if she signed that bill, that we will immediately file suit. So far, she hasn't signed it.
Now apply that standard to AR Binnered 15 style rifles. There are somewhere between 20 and 25 million of them in civilian hands in this country right now. Under Heller, a firearm that is in common use for lawful purposes by law-abiding citizens is constitutionally protected, period. The AR Binnered 15 is not just commonly owned. It is the single most popular rifle platform in America. By every objective metric the Supreme Court has ever articulated, it is protected. And yet Virginia was moving forward with restrictions targeting exactly that class of firearm.
History of the United States Department of Justice, you now have them stepping in preemptively before a bill actually becomes law.
The law makes it a Class 1 misdemeanor to make, sell, buy, import, or transfer an assault firearm.
With the last administration, when you saw a weaponization of this department, the likes of which had never been seen in history.
I can't believe what this new Governor Spanberger has done to the Commonwealth. People that voted for Spanberger are saying to themselves, why did I do that?
What the DOJ did was intervene before the laws were signed. The Civil Rights Division sent a formal notice to the state. And let me be clear about what formal notice means in this context. This was not a press release. This was not a tweet. This was a legal communication putting the state on notice that the Department of Justice has evaluated the proposed legislation, concluded that it cannot survive constitutional scrutiny under Heller, McDonald, and Bruin, and is prepared to file federal lawsuits and seek preliminary injunctions to stop enforcement if the laws are enacted. A preliminary injunction, for those unfamiliar, is a court order that blocks a law from being enforced while the case is being decided. That is the critical piece. The DOJ is not saying we will sue you and see you in court in 2029. They are saying we will ask a federal judge to stop this law before it ever touches a single gun owner. Here's the broader context, and this is where it gets really important. The DOJ chose to house this action in the Civil Rights Division. That is not an accident. That is a deliberate institutional statement. The Civil Rights Division was created to enforce constitutional rights against state government overreach. When the federal government decided that voting rights required proactive federal protection under the Voting Rights Act of 1965, it did not wait for individual black voters in Mississippi to hire lawyers and file their own cases. It sent federal enforcement directly. When the federal government decided that housing discrimination violated civil rights under the Fair Housing Act of 1968, it did not wait for individual families to litigate for a decade. It acted. The decision to deploy the same division, using the same enforcement posture, for Second Amendment violations is a signal. It means gun rights are being treated with the same institutional seriousness as every other civil right the federal government has historically chosen to actively protect.
Virginia will no longer allow for the sale, making, or purchase of assault weapons, with some exceptions.
Governor Spanberger said she signed the bill, quote, to protect families and support the law enforcement officers.
Spanberger said she signed it because, quote, firearms designed to inflict maximum casualties do not belong on our streets.
I know that Congress must reinstate a ban on the manufacturing, sale, and transfer of military-style weapons.
Now let me connect this to what is happening in the courts right now, because the DOJ's position does not exist in a vacuum. In Duncan v. Bonta, the challenge to California's magazine capacity ban, the court has already applied the Bruin standard and found that magazines holding more than 10 rounds are protected because they are in common use. That case is still working through the system, but the reasoning maps directly onto what the DOJ warned Virginia about in the challenges to New Jersey's anti-carry framework following Bruin. Preliminary injunctions have already been granted against portions of the state's sensitive places restrictions. That is because courts found those provisions had virtually no chance of surviving the Bruin test. The constitutional momentum is real and it is accelerating, and the DOJ just added federal enforcement resources to that momentum.
You had this department who stood idly by while states tried to keep President Trump off the ballot.
Weapons similar to those I carried in Iraq and Afghanistan have no place in our streets, in our communities.
I bill the mental health access and gun violence prevention, which increase access to mental health treatment in this bill.
We're ready to take on every avenue possible to make sure that this law gets blocked and that Virginia citizens have the right to keep and bear arms.
Let me be honest with you about what this is and what it is not. Is this the end of the fight? Absolutely not. Courts still decide cases. Judges still have discretion on preliminary injunctions. Some of these laws will survive challenge either because courts interpret Bruin differently or because the government manages to produce historical analogs that satisfy the test. The DOJ issuing a warning is a starting point, not a conclusion. Whether it leads to filed lawsuits, whether those lawsuits produce injunctions, whether those injunctions hold on appeal, all of that remains to be seen. I'm also not going to pretend that federal enforcement posture cannot change with a future administration. It can. What I will say is that the signal matters right now because it changes the political calculus for every state legislature in the country.
She would sign it no matter what either way, but even she and her own office admit that this is a bad bill.
Supposed weaponization of this Department of Justice, it means nothing to me because it's completely false.
This article says the mass shootings where stricter gun laws might have made a difference.
There have been more and more shootings. It is getting worse and worse. Mass shootings have occurred in the workplace, on college campuses.
When a state legislator knows that signing a gun restriction will trigger an immediate DOJ lawsuit and an injunction motion that generates national news coverage, the cost-benefit analysis of that vote changes. Some will vote for it anyway, but the marginal votes the legislators who supported these bills because they knew the legal consequences were 5 years away and politically invisible. Those votes get harder to cast when the federal government is promising to be in court next month. Here's where things stand right now and what you need to know. The DOJ's Civil Rights Division has formally put Virginia on notice regarding proposed restrictions on commonly owned semi-automatic firearms. If those laws are signed, federal litigation and injunction requests are expected to follow. The constitutional framework under Heller, McDonald, and Bruin has never been more favorable to your rights. The federal government is now actively positioning itself as an enforcement mechanism for those rights rather than leaving individual gun owners to carry the entire burden of litigation alone. If you're in a restrictive state, the precedent being set in Virginia maps directly onto the laws you're living under right now.
It makes all of us less safe. We need universal background checks.
But the American people are 70% for banning various weapons that are assault weapons.
Congress should also pass safe storage legislation to protect kids from being harmed by loaded weapons.
Watch what happens next, because the DOJ either follows through or it does not. And that follow-through is going to define whether this is a real shift or just a warning shot. I'm tracking every development on this as it happens. That is it for today, folks. See you in the next video.